Good morning. Thank you so much for joining us for today's Wednesday webinar, where we will be talking about Social Security disability for Alzheimer's disease. Before we get started, I want to give my typical warning at the outset, which is that today's webinar is not intended to be legal advice, but is instead meant to just serve as additional background information with respect to Social Security disability claims, particularly those with a Alzheimer's disease diagnosis. And as we'll talk about in a minute too, we do cover early onset Alzheimer's disease and that compassionate allowance that's included within the Social Security Administration regulations as well. Because today's webinar is not meant to be legal advice, I also do not take any questions on the live webinar, and I'm limited in what we can respond to as far as comments on the replay. I don't do that because I don't want to help. I do it because I don't want you to provide a whole lot of information where other people may be able to see or hear it. Instead, what I ask that you do is schedule a time to chat. If you're on the live, we'll go ahead and drop a link in the chat now. If you're watching on the replay, that link to schedule a call will be down below. Feel free to click the link, schedule a call at a time convenient for you, where you and I can kind of sit down and talk and chat about what's going on and whether Social Security disability may be an option for you. Also, if for some reason we cannot help, we do try to put you in touch with somebody who can. So with that out of the way, let's go ahead and get started. Here's our roadmap for today. I actually just realized that we're missing a bullet point. We will talk about Social Security disability basics, some guidance, especially as it relates to compassionate allowance. We'll talk about the compassionate allowance. We will talk about two potential listings that may tend to be met when it comes to Alzheimer's, and then also some considerations, and then close out the same way we always do, which is how an attorney may be able to help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability, PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, which means we help clients with their SSDI and SSI claims from the initial application stage through to the appeals council. We at this time are not handling federal appeals. If you do have a federal appeal question, you can always reach out. And again, if it's something that we cannot help with, we do try to connect you with somebody who may be able to. Here is some additional or just some background information on Social Security disability. These are the basics. When you apply, there are two different programs under the Social Security disability umbrella. There's Social Security Disability Insurance, or SSDI benefits, and there's Supplemental Security Income, or SSI benefits. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months. Where they differ is SSDI depends on your work history. So to qualify for and receive SSDI benefits, you must have sufficient work credits, which we typically say you must have worked for 5 of the last 10 years. SSI does not have the work history requirement, but it does have income and asset restrictions. So you cannot qualify for SSI benefits if you have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married. The income restrictions is in addition to that. So there are separate income restrictions, and those vary depending on household size, who all is in the household. So it's not necessarily as black and white and easy to spit out as the asset restrictions are, but there are also additional income restrictions. And so what we'll usually say when we've got somebody who is below the asset threshold, but there is income coming into the house, whether that's their spouse works, or they live with a parent or a child who has income coming in, I will usually kind of point in the right direction as to where you may be able to find that information. But usually I'll say to call Social Security directly, let them know that you want to apply for SSI, but that you do want to make sure that your income does not exceed their allowable threshold. And they should be able to give you guidance on that, or schedule a time in the future for somebody else from the agency to be able to take your information and see if you would qualify for SSI or if your income exceeds the threshold. When you submit your application for SSDI or SSI benefits, the first thing the agency is going to look at is SSDI or SSI. So they're going to make sure that if you've applied for SSDI, that you meet that extra prong of the work history requirement. And if you've applied for SSI, they're going to make sure that you meet that extra prong of the income and asset restrictions. As long as you make it through that, you would qualify for the program. They can start to look at the medical, and they can start to see, number one, are you engaging in substantial gainful activity? Right now, substantial gainful activity is defined as working more than 20 hours a week or earning more than $1,470 a month. If you are doing either of those, working more than 20 hours a week or earning more than $1,470 a month in gross earnings, you will stop right there at the analysis. You'll get a denial. Social Security will say you cannot be found disabled under our rules because you're currently engaging in substantial gainful activity and you cannot be found disabled. If you are not engaging in substantial gainful activity, it'll move to step 2, where they look to see, do you have one or more severe medically determinable impairments? So this is where they're going to look at your medical records and they're going to see, okay, do you have conditions that limit your ability to function on a daily basis? If you don't have any medical conditions that prohibit you from engaging in activities of daily living, you'll get a denial at step 2. The agency will say you cannot be found disabled because you do not have any severe medically determinable impairments. As long as you have at least one severe medically determinable impairment, the agency will move to step 3, where they will review your medical records to see, do you meet or equal a listing? Again, we'll talk about 2 listings in just a moment that tend to be referred to for Alzheimer claims. If you do meet or equal one listing or more, then the agency will stop their analysis there and they'll approve your claim. You'll get a favorable decision. If you do not meet or equal a listing, they will look at your medical records, create a residual functional capacity, which is what they believe you are capable of doing despite the limitations you have as a result of your condition. They'll take that RFC and they'll say, okay, can a hypothetical individual with this residual functional capacity perform your past relevant work, which is work that you've performed in the last 15 years, long enough to learn how to do the job. If you can go back to your past relevant work, then the agency stops there. You'll get a denial. They'll say, yes, you have some limitations, but you can go back to your past relevant work. If you cannot go back to any of your past relevant work, which again, any jobs that you've performed in the last 15 years, long enough to learn how to do the job, they'll go to step 5 and they'll say, okay, you might not be able to go back to your past relevant work, but are there any jobs that exist in the national economy that you can perform based on your age, education, past work experience, and RFC? If there are other jobs that you can perform, you'll get a denial at step 5. They'll say you can perform these other jobs, and therefore you're not disabled under our rules. If there is no other work in the national economy that you might be able to do with your RFC, you can get an approval at step 5. Okay, so steps 3 and step 5 are really where we're going to see an approval happen. Here are some considerations to make. This is directly from the compassionate allowance page on the Social Security Administration's website. This is included in their POMs. Early onset Alzheimer's disease is the diagnosis of Alzheimer's for a person younger than age 65. Okay, Alzheimer's disease is a degenerative, irreversible brain disease that tends to affect older people and causes a dementia that's characterized by the gradual loss of cognitive abilities such as memory, language, judgment, and the ability to function. Physiological changes in the brain include the rampant growth of 2 abnormal structures, which can interrupt normal brain activity. Okay. As it says here, the onset of Alzheimer's disease is subtle. Memory impairment tends to be the earliest manifestation, quickly followed by learning and language impairments. And because people with early onset Alzheimer's disease are often in the workforce, it's not uncommon for the disease to first manifest as a decline or loss in their ability to perform work-related activities. In the early stages of Alzheimer's disease, depression tends to be a common complaint. In the later stages, we start to see more agitation, changes in personality and behavior, restlessness, and withdrawal. Okay, so that is kind of what the agency is looking at as far as Alzheimer's disease. Again, if you've got the diagnosis, somebody that you know or love has the diagnosis, really doesn't need to be explained to you, but this, just for additional background information purposes, is what the agency is looking at. Again, it came directly from their POMs and their compassionate allowance website. Here's one of the listings that Social Security tends to consider Alzheimer's claims under, listing 11.17, neurodegenerative disorders of the central nervous system. So you'll see here it's going to require that you meet A or B. A is the disorganization of motor function in two extremities, resulting in an extreme limitation in the ability to stand from a seated position, balance while standing or walking, or use the upper extremities. Okay, so if the medical records point to that and there's an Alzheimer's disease diagnosis, that's where you can meet that listing. Or a marked limitation in physical functioning, as well as one of the following 4 mental limitations: understanding, remembering, applying information, interacting with others, concentrating, persisting, or maintaining pace, or in the ability to adapt or manage oneself. And those 4 areas of mental functioning we will see in the next listing as well. I'll leave this up for just a minute. Like I said, this is one of the 2 potential kind of more common listings that we see for Alzheimer's disease. Here's listing 12.02, which is the other one that we tend to see. This is for neurocognitive disorders. So you need to have either A and B or A and C. Okay, so no matter what, you've got to meet A, which is medical documentation of a significant cognitive decline from a prior level of functioning in one or more of those cognitive areas, including complex attention, executive function, learning and memory, language, perceptual motor, or social cognition. So the medical records have to point to that significant cognitive decline from a prior level of functioning in one of those 6 areas. And then you also have to have medical documentation of either A or B, which is B is that extreme limitation of 1 or marked limitation of 2 of those same 4 areas of mental functioning from the last listing. So that's understand, remember, apply information, interact with others, concentrate, persist, or maintain pace, and adapt or manage oneself. If you don't meet A and B, you may be able to meet A and C. So C is going to require the mental disorder to be serious and persistent, which means that you have to have a medically documented history, that the disorder has existed over the last 2 years, and there's evidence of medical treatment, therapy, psychosocial support, or a highly structured setting that's ongoing and limits the symptoms and signs. And there's a marginal adjustment, meaning you have minimal capacity to adapt to changes in your environment or to demands that are not already part of your daily life. So A and B or A and C. Typically with Alzheimer's, we're not going to see A and C met. So we're going to likely look at A and B. And the reason why A and C is not too common, of course, is because it does require that 2-year period of documentation. It's possible, but it's not one of the more common things that we see. Considerations, as always, medical records are paramount. As you just saw in the listings, they are going to require medical documentation, not just you saying, oh, I noticed a cognitive decline, and your family and friends and coworkers all saying that same thing. There has to be medical evidence of that. There's no specific clinical or laboratory diagnostic test for Alzheimer's disease. The diagnosis can really only be confirmed by brain biopsy or a post-mortem examination of the brain. The diagnosis of early onset Alzheimer's disease tends to be based on the combination of clinical and family history, neurological, cognitive, or neuropsychological exam, and neuroimaging. Okay. Again, these second 2 bullets came directly from the Social Security Administration's Compassionate Allowance website. So it's specifically really talking about early onset Alzheimer's disease. What they're going to be looking at as far as pertinent clinical information in the medical records is going to include the history of the onset, description of cognitive and functional impairments both at home and at work, a decline in the mini mental status exam. Those scores over time can be an indicator of possible dementia. Sometimes doctors will do those when you just go for your annual visit. Just a quick questionnaire, and so that might be helpful to have. Neuroimaging, including CTs and MRIs, is also, of course, useful for observing any changes in the brain and for excluding other potential causes of dementia. Here's how an attorney can help you. Again, this is not an exhaustive list. It's just kind of some of the things that we tend to do most often, or what we get questions about most often. We can provide guidance on what correspondence from the Social Security Administration actually means. We see that often where clients will get letters and they just get papered with paperwork from Social Security. They're like, I have no idea what any of this means. Well, that's one of the things that we do, help explain that. We're actually right now working on having a web page for current clients to be able to log into, to be able to watch videos of kind of those types of explanations. So they may be able to watch it again and again while they're filling out that paperwork. If you are already a client of ours, or you reach out to us within enough time after a denial, we can help file necessary appeals. We do review your medical records and case file. We can discuss what additional records may be helpful in your case. We can review your documents for accuracy and completeness and discuss what Social Security is looking for in their requested forms. So there's kind of been 3 bullet points on that now. We do not fill out forms that Social Security sends about your day-to-day activities for you. And the reason for that is because you know what you're going through better than anybody else. Having a family member or a friend help you fill that out is going to likely be more effective and more efficient than having us try to help. Because, even if we tried to understand, and we do, we, aren't there in your shoes day to day. And so that's really what Social Security is looking for on those forms. We work with you to provide relevant updates to and from Social Security throughout your claim. If it has to go to hearing, we do prepare you for that hearing. And then, of course, question you and any potential witnesses during that hearing. Typically, the witnesses that we're talking about are going to be vocational and medical witnesses. If you've got personal witnesses that you would like to bring in as a witness, which can be helpful, especially in Alzheimer's cases, that is certainly something to discuss. And if you're a client of ours, we definitely discuss that well in advance of the hearing, kind of how we work on getting that additional witness testimony in. Okay. Here's our contact information. Please feel free to give us a call, send us an email. We'll go ahead and drop the link in the chat again if you would like to schedule a call at a time convenient to you. We are always happy to answer any questions. Thank you so much for watching. Have a great day.